judge looked down at my mother over her reading glasses, and for a second the whole courtroom went so quiet I could hear the ventilation humming in the ceiling. My mother straightened her blazer. She had worn the cream-colored one. The nice one. The one she used to wear to church before she stopped going. I hadn't seen her in 11 years. Let me take you back to the part that still doesn't feel real, even now that I'm 31 and have a mortgage and a coffee maker that costs more than anything I owned until I was 19. I was 6 years old the afternoon my parents drove me to the Kroger on Millbrook Road in Raleigh and didn't come back. I remember the cart. I remember holding onto the side of it while my mother picked up a box of cereal and put it back down again, the way she always did when she was pretending to think about money. I remember the automatic doors opening and closing at the front of the store. I remember looking at the fish tank they had near the floral section, the one with the better fish that turned colors under the light. And I remember realizing, somewhere around the time the store started playing a second song, that I hadn't seen either of them in a while. I walked the whole store twice. I checked the parking lot. A woman in a yellow vest asked me if I was lost, and I said no because I didn't understand yet that I was. Then she asked me my name and I told her. She asked me my address. I knew it. 4417 Carleton Drive. I knew my phone number too, the landline, because my father had made me memorize it when I started kindergarten. She called. No one answered. She called twice more over the next 20 minutes while I sat in the manager's office eating a sleeve of crackers someone found in the drawer. Then she called the police. The officer who came was a woman named, I still remember her name tag, Officer Tran. She had short hair and a calm voice, and she kept asking me questions in the same steady tone, like none of my answers were surprising her. Where did my parents go? I didn't know. Did they say anything before they left? No. Did we come in one car? Yes. Was the car still outside? I didn't know it wasn't. I found that out later. Officer Tran drove me to the County Department of Social Services. I sat in a chair that was too big for me with a paper cup of apple juice that I didn't drink, and someone took my photo, and someone else made more phone calls, and by the time the sun had moved past the window to the other side of the building, I understood, without anyone explaining it to me, that I was not going home that night. My parents told the police I'd wandered off, that they panicked and driven around looking for me, and couldn't find me, and assumed I'd been taken. I was 6. I knew my address and my phone number and the name of my school. I know now that law enforcement can typically locate a missing child's family within hours when the child knows identifying information. My parents knew this too. That's why they drove 2 states away before filing any report at all. I didn't learn any of this until I was 24. I'm getting ahead of myself. The first foster placement lasted 3 weeks. I don't remember much about it except that there was a dog who wasn't allowed on the furniture and a television that was always on. The second one lasted almost 8 months. There was a boy there who was 12 and who was kind to me in the distracted way that 12-year-olds are kind. He let me watch what I wanted on Saturday mornings and once gave me his Halloween candy without explanation. The third placement was a woman named, I'll call her by what I called her, which was just her first name, June. June was 62. She lived in a ranch house in Durham with a garden that took up most of the backyard and a lemon tree she kept in a pot by the sliding door because she said lemon trees belonged in California. But she refused to move to California. June had been fostering kids for 19 years by the time I came to her. She had a system. Not a cold system, not a checklist, a real one, built out of accumulated knowledge about what kids who had been through the system actually needed. There was always food visible on the counter, not locked up, not rationed, just there. A fruit bowl, a loaf of bread, crackers. She said once, matter-of-factly, that kids who had been food insecure needed to see food existing passively in a room before they could stop thinking about it. I didn't know what food insecure meant at age 7. I know exactly what it meant now. She taught me to read from real books, not just school books. She had a whole shelf of them at my height, deliberately placed. She asked me what I liked and listened when I answered, and the next week there would be something new on the shelf. She never made a production of it, it just appeared. She had arthritis in both hands that made gardening harder every year, but she refused to give up the garden. Saturday morning she would let me help her, which mostly meant I handed her things and she told me what everything was called. Zucchini, sweet basil, heirloom tomatoes that she said tasted like tomatoes were supposed to taste before grocery stores decided they needed to survive a 2-week shipping schedule. I lived with June from age 7 to age 16. There is more I could say about those years, but I'm not sure I have the right words for it yet. Some things you are still in the middle of understanding even when you think you have arrived somewhere solid. What I can say is that June treated fostering not as charity but as work, and not as work but as relationship, and that distinction turned out to matter enormously. She was not trying to save me, she was trying to know me. Those are different things. When I was 9, my caseworker told me that my biological parents had been located, that there would be a hearing about reunification. I remember June sitting across from me at the kitchen table while I processed this, and not saying anything for a long moment, and then saying, "Whatever happens, you know where this house is." The reunification hearing didn't result in reunification. My parents' rights were formally terminated when I was 10. I don't know exactly what led to that determination, and the records weren't accessible to me until I turned 18. And by 18 I had decided I didn't want to read them. What I knew was this. June asked if she could adopt me, and I said yes. The finalization was on a Tuesday in March. June wore a green dress. The judge made a joke that I don't remember. We went to a diner afterward, and June let me order whatever I wanted, and I ordered pancakes even though it was 2 in the afternoon, and she ordered the same thing. June died the spring. I turned 27. She had been sick for about 8 months. An aggressive form of lung cancer, which was cruel in its irony because June had never smoked a day in her life, and frequently said so with considerable feeling. She fought it the way she did most things, which is to say methodically and without drama, showing up to every appointment, doing the research, asking the questions. She let me come to the appointments when she wanted company, and told me directly when she needed to go alone. She died on a Sunday morning in April, in the bedroom she'd slept in for 35 years, with the lemon tree visible through the window because we'd moved it to the backyard for spring. She had updated her will the previous October. I found out 3 weeks after the funeral when her attorney, a dry, precise man in his 60s named Mr. Aldridge, called and asked me to come in. June had owned her house outright. She had also, over 40 years of careful saving and a small inheritance of her own, accumulated a portfolio that I had not known the scope of. The house was valued at just under $400,000. The investment accounts totaled a little over $900,000. There were also proceeds from 2 life insurance policies, total $1.7 million. All of it left to me. I sat in Mr. Aldridge's office for a long time after he finished explaining. He was patient about it. He had probably seen this particular kind of stunned silence before. I had known June had the house. I had known she was careful with money. I had not known the scale of it. And I think more than the money itself, what I was sitting with was the understanding that she had thought about me that deliberately, that she had made decisions over years, decades, with me as part of the calculation, that I had been, without knowing it, included. I cried in the parking lot for about 20 minutes. Then I drove home and called my closest friend, and couldn't really explain it, and she came over anyway, and we sat on my kitchen floor until midnight. The letter arrived 6 weeks later. It came from an attorney's office in Charlotte, North Carolina, a firm I didn't recognize. The letter was formal and dense with legal language, and it took me 3 reads to understand what I was looking at. My biological parents were contesting June's will. They were claiming through their attorney that as my original legal guardians, a designation that had been terminated for 17 years, they had standing to challenge my inheritance. They were also claiming, in a separate but related filing, something that made me set the letter down on my kitchen counter and stand there for a full minute trying to process. They had received a life insurance payout of $68,000 when I was reported missing as a child. They were not technically asking for it back, but their attorney had included it in the claim in a way that seemed designed to imply they were owed something in exchange for it. The total amount they were seeking, $1.7 million, all of it. I called Mr. Aldridge. He had already received the notice. He walked me through it with the same dry precision he'd used in his office, but I could hear something underneath it. Not alarm exactly, but the particular steadiness of someone who wants to make sure you don't panic. The standing issue is significant, he said. Their parental rights were terminated. They are not your parents legally. A judge will need to rule on whether they have any right to bring this claim at all. And if the judge rules that they do, then we address the merits, which are not in their favor. I didn't sleep well for the next 2 weeks. I want to be honest about that. The money itself, I'm not sure I had fully integrated what it meant yet, so it wasn't about the money in a possessive way, it was about June, about the fact that the people who had left me in a grocery store when I was 6 were now reaching into something she had built for me and trying to take it. That was the part I couldn't get past. My biological father's attorney's name was listed in the filings. I'm not going to use it. What I will say is that during the first pre-trial hearing, he stood up and said with apparent sincerity that my parents had suffered the loss of their child and that this inheritance rightfully represented damages owed for that suffering. The judge, a woman in her late 50s with reading glasses on a beaded chain, looked at him over those glasses for a moment before responding. Counsel, can you walk me through the basis for your client's legal standing to contest this will, given the termination of parental rights that occurred when the plaintiff was 10 years old? He had an answer. It wasn't a good one. But he had one, and that meant we went forward. I want to tell you about the moment I decided not to spend $40,000 on an attorney, and instead spend it on 3 months of studying estate law, talking to legal aid organizations, reading every filing in my own case until I understood it, and then representing myself. That's not exactly what happened. What happened is that Mr. Aldridge, who was handling the estate administration but not litigation, referred me to a litigator, and the litigator was very good and very expensive, and told me the case was winnable but could take 18 months and cost between $35,000 and $60,000 in legal fees, depending on how hard my parents chose to fight it. I thought about that for 3 days. Then I called a legal aid clinic that specialized in probate and family law. They couldn't take my case, income threshold, but the attorney I spoke with there, a woman who sounded about my age and talked fast and gave me more useful information in 40 minutes than some people give in 4 hours, told me something I've thought about often since. She said, the strongest argument in your case is not a legal technicality, it's the factual record. You know the factual record better than anyone. A judge deciding a motion on standing is going to be looking at a paper record. Make sure your paper record is complete, clear, and tells the story in order. I read everything. I filed a response to their standing motion myself, citing relevant North Carolina case law on the post-termination rights of former parents with respect to the estates of their adult children. Mr. Aldridge reviewed it. He made 2 corrections and said the rest was solid. The standing hearing was on a Thursday morning in October. I wore a dark blazer. I had my documents tabbed and organized in a binder that I had rebuilt 3 times because I kept thinking of a better way to order it. My biological mother was there, and my biological father. My mother in the cream blazer. My father in a suit I didn't recognize. They looked older. I had expected them to look older, but it still landed strangely, the way seeing someone you've only thought of in past tense suddenly existing in present tense will do. They looked at me when I walked in. I looked at the table I was walking toward. The other attorney made his argument. I made mine. I kept my voice steady. I had practiced keeping my voice steady. The facts were simple. Parental rights terminated in 2003. Plaintiff is a legal adult. Decedent was plaintiff's legally adoptive parent. Former biological parents have no recognized legal standing under North Carolina statute to contest the will of an adoptive parent on behalf of an adult adoptee. I cited 3 cases. I handed the judge copies with the relevant passages flagged in yellow. She read. The room was quiet. The ventilation hummed. I'm going to take this under advisement, she said. But I'll tell you that I find the standing argument here extremely thin. Counsel, I'd encourage your clients to consider whether this proceeding is in their interest to continue. They continued it. The full hearing was 6 weeks later. By then I had gotten better at this, the way you get better at anything when you have no alternative. I knew the case, I knew the documents, I knew what they were going to argue because their filings told me, and I had responses to all of it. Their central argument, stripped of the legal language, was this. They had raised me for the first 6 years of my life. My adoptive mother had built wealth partly during a period when I was in her care. They were owed something for their contributions to my upbringing. I want to tell you that in the courtroom I was calm and that I addressed this argument with precision and appropriate professional distance. I was mostly calm. I addressed it with precision. Your Honor, I said, the record shows that my biological parents abandoned me in a retail location in June 2000. I was 6 years old. I knew my home address. The responding officer documented that I was able to provide complete identifying information within minutes of being found. No attempt was made to retrieve me. Parental rights were terminated 4 years later following review by this state's Department of Social Services. My adoptive mother, June. And here I had to stop for just a second, because I hadn't said her name out loud in a formal setting since the funeral, provided for me from age 7 until her death this year. The argument that my biological parents' 6 years of legal guardianship, which ended in abandonment and formal termination, entitles them to an inheritance built by someone who actually raised me, is without merit in law or in equity. The judge looked at me for a moment. Do you have anything further? No, Your Honor. She ruled in my favor on all counts. The standing argument failed. The merits argument failed. The merits argument failed. The motion for reconsideration that their attorney filed the following month was denied. I found out by email. Mr. E. Aldridge forwarded me the decision with a short note. As expected, congratulations. I sat at my kitchen table for a long time. I wasn't happy in the way I thought I would be. I thought there would be relief, and there was, underneath everything, but mostly what I felt was tired and sad in a way that was different from grief. More like the particular exhaustion of having had to defend something that should never have required defending. June's house sold 3 months later to a young couple with a baby and a dog. Before the closing, I went through it one last time. The lemon tree was still there. I had kept watering it because I didn't know what else to do. I took it with me. It lives in my apartment now, near the east window, where it gets morning light. I used a portion of June's estate to establish a fund through the Durham chapter of a non-profit that supports foster youth transitioning out of the system. Kids aging out at 18 with no family safety net, which is more of them than most people know. The fund provides emergency housing assistance and first-month deposits for apartments. It's not a grand gesture. June would have been annoyed by grand gestures. It's just a practical thing that helps with a practical problem that she would have understood immediately. I kept her recipe box, her reading glasses, the lemon tree. I kept the memory of her at the kitchen table that morning after the reunification hearing saying, "Whatever happens, you know where this house is." She meant it as a practical statement. That was how June operated. But I have thought about that sentence almost every day for 24 years. And I think it was also the most complete definition of home I have ever been offered. You know where this house is. I knew. I always knew. And it turns out that knowing is the thing that doesn't go away. Even after the house does. Even after the person does. The knowing stays, which is maybe the only inheritance that really can't be contested.